everybody. I'm Susan Alvarado, and welcome back to Legal Action. As you probably know by now, our program is sponsored by the DuPage County Bar Association and is designed to help educate and inform our community about important areas of law which affect our everyday lives. In the past, we've discussed many important issues, including domestic violence, the problem with teenage drinking and driving, and home foreclosure issues. And today, we're here to discuss another area of law which touches our everyday life, and that is worker compensation issues. We have here with us today attorney Kevin Millen. Kevin is an experienced and an accomplished lawyer who practices here generally in Wheaton. He has offices in Wheaton, in Arlington Heights, and in Chicago. Kevin is a partner with the law firm of Millen and Peskin, and among Kevin's many accomplishments, he is the past president of the DuPage County Bar Association and the 2009 recipient of the Ralph Gabrick Award, which recognizes professionalism, excellence, and integrity in the legal profession. Kevin, thank you very much for being here with us today.
Susan, thank you for inviting me. I appreciate being here.
Our pleasure, Kevin. I'd like to start off today, if we could, by talking about how and why our legislators decided to handle work-related injuries differently than they might handle injuries that occur out in the home or outside of the workplace. Can you give us a little background on that, Kevin?
Sure. The Workers' Compensation Act and the way that work injuries are handled in the state of Illinois really is, in a sense, kind of a negotiated agreement between labor and management as to how they're going to handle work injuries. If you left it up to just a negligence system, which is the general way that accident cases are resolved, you have to prove that your employer would be at fault for your injury. But that also has a higher threshold of damages. Under the Workers' Compensation Act, you don't have to prove your employer was at fault. You don't have to prove anybody was at fault. And therefore, it opens it up to a lot more coverage. In other words, more injuries are covered. Right. But in return for that, the damages are capped. In other words, what you can recover out of a workers' compensation case are much less than what you could recover in a negligence-based system.
Well, that's really very interesting, and I want to talk more in depth as we go on with this program today about the benefits that are available under the workers' compensation laws. But one question that comes to my mind right now is, I think it's very interesting that you've told us that we should think about workers' compensation laws as sort of a no-fault system,
correct,
right?
Correct.
That unlike the negligence system, we don't have to spend a lot of time in court proving fault, yes? Mm-hmm. So, Kevin, what happens if I believe my employer actually was at fault for my injury? Do I have two lawsuits there?
No, you don't. Again, this whole negotiation and what the agreement is, certainly part of what the employers got out of it was the protection against the more expensive negligence lawsuits. Okay. So there is a clause in the Workers' Compensation Act that says that this is an employee's exclusive remedy for any work injury.
Okay, so if I'm injured at work, then my exclusive remedy is a workers' compensation suit, correct?
Correct, but I'm going to put one caveat on that, all right? It's your exclusive remedy against your employer. Oh, now, right. Let me just give you a for instance, okay? Let's say I'm a delivery driver and I've left my employer's warehouse and I'm on my way to a delivery, mm-hmm. and somebody else runs a red light, hits me, and injures me. Yeah. In that situation, I would have two claims. I would have my workers' compensation claim against my employer, but I would also still have a negligence claim against the person who ran the red light and hit me and injured me.
Oh, interesting. I hadn't even thought of that. That's right. So that would apply in the context of, as you said, a delivery driver, because mm-hmm. that's part of his job, yes?
Right. Correct.
To be driving around.
Correct.
Okay, so here's another good question. I actually collected some questions from our viewers, so we have some really good questions we're going to put to you today, Kevin.
Good.
So if I'm injured, again, to go back to this on my way to work scenario,
Right.
if I'm injured on my way to work and I'm a lawyer, I'm not a delivery driver, and I'm in a car accident on my way to the office, is that a workers' compensation claim?
It is, but I'm going to give you a little variant on it too. Okay, if you're leaving your house and you're on your way to your office and there's an automobile accident. In that situation, yes, it's a workers' comp, or I'm sorry, no, it's not a workers' compensation
No, it's not.
claim.
Okay.
Correct.
Okay.
You're on the way from your house to your office. But let me throw a little something else in there. Let's say you are on your way from your house to the courthouse. Then it is covered.
Oh, okay.
So there's a lot depends, but generally if you're on your way from your house, it doesn't cover travel from your home to your place of employment. And since the law is written with to your place of employment,
Right.
if you're on a errand for work somewhere else,
Right.
it does then become part of the employment.
Oh, so it doesn't sound like it's a black and white response.
No,
then,
not
right?
always. No.
Yeah, that's usually the case, isn't it, wherever there's legal issues involved.
It absolutely
Yeah.
is.
Well, I'll tell you right up front what I would say here to all of our viewers is in all of these instances, we can't possibly cover everything here today, and I would strongly recommend to any of our viewers out there, if you are injured at work or if you become ill as a result of your employment, it's worth a phone call to somebody like yourself, Kevin, or some other worker compensation attorney to ask these questions.
Absolutely,
yes.
yeah. Knowledge is power, and it's good to know what your rights are.
Well, here's another good question that somebody put to me one day, and it's on the day that this employee got injured at work, he didn't think anything about it. He didn't think it was a big deal, so he went home.
Right.
He went home, he didn't get any better, he waited a while, and when he went back to work and told his boss of the injury a few days later, his boss said there was nothing he could do about it because the injury wasn't immediately reported. What do you have to say about that, Kevin?
He's wrong.
Well, that's good to know.
Yeah, the Workers' Compensation Act gives an injured employee a 45-day window to report an accident to your employer. So the fact that, and it happens a lot, certainly. I mean, you know, people don't want to feel like they're complaining about every little thing that happens. So a lot of times it's very common that a person will go ahead, you know, something will happen to them, they'll go home, they'll think it is going to get better. A few days later they realize it's not. And they go to their employer. That's absolutely fine. As I said, you've got 45 days to tell your employer about a work injury. Certainly, I would suggest that once you're going to do it, make sure you get in there, you notify your employer, you do it in writing, and then you go see your doctor as soon as possible, and make sure you give the doctor a good history of what happened and why it is you're there to see him and what the injury was.
Right. Well, that's good to know. That 45-day period is good information to have. But Kevin, what about a situation where an employee was injured at work, say, I don't know, 12 months, 18 months ago and didn't report it? What's the likelihood of pursuing a successful workers' compensation claim under those circumstances?
Not really good. I mean, I said the 45 days, and I will give a little bit of a caveat to that, in that the courts will be liberal in their interpretation of that and their application of that 45-day window. If there was a good reason, I mean, if, for instance, they just didn't think it was a problem and, you know, then it got worse.
Right.
The courts may, and again, I'll say never count on this, but the courts may extend that 45-day window. But if you're talking about something that's 12 months, 18 months, it's probably not a real good likelihood at that point.
Okay.
And one other aspect of the question